Hello, everyone, and welcome to this 1 hour Quinn Emanuel panel discussion, Executive Stock Trading Plans in the Crosshairs. My name is Kurt Wolfe. I am of counsel in Quinn Emanuel's Washington, D.C. office, and I am a member of the firm's SEC Enforcement Defense Practice. And today I will serve as your moderator for this timely panel discussion. I'd just like to thank everyone for joining us today, including our expert panel of Quinn Emanuel partners, who I'll introduce in just a moment. When we were planning this webinar, we didn't realize that we would be competing with Lionel Messi for an audience. So I appreciate everyone that took time out to tune in today. I promise there will be no spoilers during this webinar, and we will get you out of here in time for the second half. So with that, let me give you a little bit of a roadmap of what we'd like to cover today, and then I'll introduce our panel. As I mentioned, we are going to dedicate this hour to a conversation about executive stock trading plans, which are commonly known as 10b5-1 plans. Essentially, Rule 10b5-1 creates an affirmative defense against insider trading charges for corporate insiders, usually senior executives, who may have access to material non-public information, but buy or sell their company's stock pursuant to a prearranged trading plan. The defense exists if that plan was adopted in good faith and while the executive was not in possession of material non-public information. I will probably refer to that as MNPI today. These plans are widely used, but over the last several years, there have been a number of academic studies and other reports which suggest that corporate executives may be misusing these plans to arrange profitable trades or avoid losses. So far, there have been precious few SEC enforcement cases concerning 10b5-1 plans, and none are very recent. But this fall, we saw evidence that change may be in the wind. In September, the SEC brought an enforcement action in which it charged two corporate executives with insider trading for selling their company's securities pursuant to a purported 10b5-1 plan while they were in possession of material non-public information. And on the heels of that enforcement action, it was reported in Bloomberg, Reuters, and elsewhere that the SEC and DOJ are conducting parallel investigations and sending subpoenas to public companies regarding executives' use of 10b5-1 plans. So today we're going to talk a little bit about the contours of Rule 10b5-1, discuss the scope of the SEC and DOJ 10b5-1 sweep, and explore steps companies and executives can take to stay out of the crosshairs. Just a programming note, I'll be monitoring the Zoom chat for any questions you may have during our presentation today, so please feel free to dump them in the chat and we'll get to as many as we can. So with that preamble, let me just take a moment here and introduce our panelists who I'm excited to see in person for a change here in Washington, D.C. Immediately to my left is Sarah Heaton Concannon. Sarah is a nationally recognized first chair trial and appellate lawyer who, together with Michael Liftik, also on our panel, serves as co-chair of Quinn Emanuel's SEC Enforcement Defense Practice. Sarah regularly advises public companies, private funds, hedge funds, investment advisors, boards, audit committees, senior executives, and other individuals in bet-the-company litigation and government investigations. Before joining Quinn Emanuel last fall, Sarah held senior positions at the SEC, including as senior trial counsel and as senior counsel to the co-directors of enforcement. To Sarah's left is Michael Liftik. As I mentioned, Michael is a co-chair of the firm's SEC Enforcement Defense Practice. He is also a co-managing partner of the firm's Washington, D.C. office. Michael's practice focuses on government and internal investigations, regulatory enforcement defense, securities litigation, congressional investigations, crisis management, cybersecurity, and cryptocurrencies. Before he joined the firm, Michael was the deputy chief of staff of the SEC, where he served as a senior legal advisor to Chair Mary Jo White. He also served as Chair White's senior advisor on enforcement, and prior to his service in the chair's office, Michael was counsel to the director of the Division of Enforcement. And last but not least, we're going in alpha order here. Rob Zink, all the way at the end of the table. Rob is a trial lawyer and a member of the firm's investigations, government enforcement, and white-collar criminal defense group. Rob's practice focuses, among other things, on trying high-stakes matters, defending corporate entities and individuals under investigation by federal and state law enforcement authorities and regulators across the United States. Before he joined the firm, Rob served in various capacities at the U.S. Department of Justice, most recently as acting Deputy Assistant Attorney General in the department's Criminal Division, and before that, as Chief of the Criminal Division's Fraud Section. So I think you'll all agree with me that we have probably the best panel imaginable for this discussion today. Excited to have them. Thank you all for joining. So let's start with some basics or some background on Rule 10b5-1. As I said, we want to talk a little bit about the contours. I offered a couple sentences up front just to introduce the concept, but for the benefit of attendees who may not be familiar with the rule, Sarah, can you explain the purpose and contours of the rule?
Thank you, Kurt, for the really nice introduction and for the first question. So Kurt really hit the high points, but Rule 10b5-1 was established over 20 years ago, and it really was intended as a practical solution to a very real problem, which is that insiders of companies, senior executives, directors, and officers typically have substantial stock holdings in the stock of the company. They also, by virtue of their rules, by definition, have access to material non-public information. So 10b5-1 plans were established in order to ensure that those insiders still have the ability to trade on their stock without running awry of the insider trading rules. So as Kurt reflected, it's essentially an affirmative defense to a potential insider trading charge, which states that if you put in place a 10b5-1 plan on effectively a clear day, a day when you do not have information that would otherwise be material non-public information, and that plan sets out the parameters of the number of shares you're going to trade, the price at which you're going to trade, and the time you're going to trade, you can then trade pursuant to that plan, even if at the time that particular trade is executing, you do have in your possession material non-public information. So it really creates a nice protection for insiders at companies to have in place these plans and then trade pursuant to them on a periodic basis. And it shifts the question of when you had MMPI from the question of whether you had material non-public information at the point in time you were trading to whether you had material non-public information at the point that you entered into the 10b5-1 plan.
As I sort of previewed, Sarah, it sounds like there have potentially been some gaps in that rule that were exploited or allegedly exploited by executives over the years. And I think to that end, there has been some proposed amendments to the rule. So could you walk us through how some of those amendments might change the landscape?
So thank you for throwing allegedly into the mix. But so certain folks at the SEC have, and really commentators more broadly, have looked at 10b5-1 plans and essentially said, there are gaps, there are loopholes, there are ways in which 10b5-1 plans can be exploited, potentially. So back almost a year ago now, in December of 21, the Gensler administration proposed a series of rule amendments to 10b5-1 plans that would put in place some measures to effectively try to fill these gaps. And this is still pending rulemaking. Nothing has happened over the course of the year other than that the proposal is out there, and this is currently part of what the SEC has suggested it might want to do in this space. So in particular, the types of gaps, to use Kurt's words, that would be filled by the proposed rulemaking is that it would put in place a mandatory cooling off period. So right now, under the existing rule, I can enter into a 10b5-1 plan on Tuesday and I can trade on Wednesday. From the SEC's perspective, that creates the risk that you in fact are establishing a plan for the purpose of trading on material non-public information. So under the proposed rule, there would be a 120-day cooling off period. It would also require certifications by the directors and officers who are entering into these plans on that issue that I flagged earlier, which is at the time I entered into the plan, was I in possession of material non-public information? So it would create an upfront good faith requirement for me to certify that on Tuesday, when I entered into the plan, I was not personally in possession of any MMPI. This if passed, will be a really nice enforcement tool because it will basically make it much easier for the enforcement division to bring an action because of the falsity of my certification, rather than trying to establish, other more difficult parameters of an insider trading case. Other things that are filled by the proposed rulemaking: you can't have overlapping plans. You can only have a single plan over the period of a 12-month, so 1 year period. And again, that good faith requirement that is put in place. One question that's probably front of mind is this thing's been hanging around for 11 months plus now. When are these rules likely to see the light of day? That requires a little bit of guesswork. And what we can say is that this is far longer than most rulemakings under the Gensler administration have sat without moving forward. So there is some suggestion, both because of the Cheetah Mobile case, which Kurt flagged earlier, and we'll talk about more later today, and the sweep that Kurt flagged earlier, and we'll talk about more later today, that the commission is moving toward finalizing this rulemaking sometime in 2023. The important thing about Cheetah Mobile in particular is that a number of the remedies that were put in place in that case are things that are directly contemplated by the proposed rulemaking. So it does suggest that essentially the Division of Enforcement didn't wait for the finalized rulemaking in order to move forward with the enforcement action, but it gives you some sense that the commission does think that this is an appropriate place for them to be, again, filling these gaps.
Thanks for that. We'll have to keep our eye out for the final rule. And it's interesting that this one case maybe kind of tips the SEC's hands, at least in terms of what they think this final framework might look like. Despite the fact that there are some recent developments, I actually remember about 10 years ago, there were rumors that the SEC in particular was focusing on 10b5-1 plans and potentially going to crack down again on these perceived abuses by certain executives or companies. Michael, at the time, you were at the commission, you were on the staff serving as counsel to the director of enforcement. So, I wonder if there was any truth to the rumors at the time. Is this something that the SEC has been focusing on periodically?
Well, to pull out a line from my past, I can neither confirm nor deny the existence of a focus. But what I can say is that 10b5-1 plans, and the staff's interest in it is cyclical. It does come up from time to time that staff get the sense that these plans are not being used as they're supposed to be, which is to allow executives to diversify their holdings, to appropriately sell their stock, but actually are being used as a tool to manage around the information that they have, and obviously in some cases to abuse the information that they have. So it does go up and down. The big difference between today, which we'll talk about, and 10 years ago really is the tools that were at the disposal of the Division of Enforcement. Investigating insider trading cases, whether there's a 10b5-1 plan or not, is challenging. They are usually built on circumstantial evidence. And 10 years ago was the very beginning of the division's work in developing data analytical tools that enhance their ability to bring those types of cases. So at the time, when I was there, insider trading cases tended to be more whack-a-mole. And so the idea of taking on 10b5-1 plan trading in a systematic way might have been an attractive policy idea for the division, but putting it into practice would be more challenging. I'll also note that if we think back to what happened in the insider trading space 10 years ago, that's 2012 or so. That's roughly the period of time that the expert networks cases started breaking, the Gallian Rajaratnam insider trading cases started breaking. So one could posit that the division's attention was being directed elsewhere, not at issuers and executives at issuers, but over in the hedge fund space. And obviously there's a long string of cases that emerged from those cases.
It's helpful context. You're on the record neither confirming nor denying. So I guess we'll try again with Rob. I would like to get your perspective from the DOJ. I think at the time, about 10 years ago that I was talking about, you were serving as the assistant chief of the Securities and Financial Fraud Unit. Obviously, you went on to bigger and better things. But while you were in that role, do you recall a focus on 10b5-1 plans?
will not be able to provide much information here because there really were no investigations of that type at the time. And I can tell you, just as a practical matter, that had a case of that variety come on my desk, at least as a supervisor in the unit at the time, the existence of a plan and the existence of the affirmative defense in the rule would have almost been dispositive, in that we would not have taken the case likely.
Right. Interesting. So it sounds like maybe the SEC was looking at this for a time. It sounds like DOJ was not. Regardless, I think there is some evidence out there that the SEC and DOJ are focusing on 10b5-1 plans today, and that's why we're here. That's what I think is critically important. Rule 10b5-1 has been on SEC Chair Gary Gensler's regulatory agenda since he took over as chair a couple of years ago. And of course, Sarah told us a little bit about some of the work that he and the commission have been doing in his time through rule amendments or proposed rule amendments to Rule 10b5-1 that could potentially change the landscape. But in addition to what he's doing from a rulemaking perspective, the commission is under considerable pressure from lawmakers on the Hill to finalize those rules and crack down on reported abuses of Rule 10b5-1. In fact, in a recent letter to Chair Gensler, Senators Elizabeth Warren, Chris Van Hollen, Tammy Baldwin, and Bernie Sanders urged the commission to close 10b5-1's, quote, loopholes and, quote, act swiftly to ensure that Rule 10b5-1 is no longer viewed as a get out of jail free card, end quote. Not long after the senators sent the letter, the SEC brought the Cheetah case, which Sarah and I mentioned. In that matter, the SEC charged the CEO of Cheetah Mobile and the company's former president and chief technology officer with insider trading for selling Cheetah's shares pursuant to a purported 10b5-1 plan when they had possession of MNPI. According to the SEC's order, the executives jointly established a 10b5-1 plan after becoming aware of a significant drop-off in advertising revenue from the company's largest advertising partner. And through the trades authorized under the plan, the executives avoided hundreds of thousands of dollars of losses. Also, as I mentioned earlier, Bloomberg and other outlets have reported that the DOJ and SEC are sending subpoenas to public companies requesting information about the companies or their executives' reliance on 10b5-1 trading plans. In fact, one company has disclosed publicly that it has received subpoenas from both the SEC and the Justice Department, including a grand jury subpoena seeking materials concerning the trading activities of a former CEO. So with all that said, I think it's safe to say that maybe things are a little different than they were 10 years ago in terms of the regulatory or enforcement focus. Michael, I want to come back to you to talk a little bit about the genesis of these cases or how the SEC might work them up. You mentioned that they perhaps have better tools now than they used to. So how is the SEC finding conduct that they think may violate the rule?
Well, in order to answer that question, you have to take a step back and look at how does the SEC investigate insider trading cases generally. And back in the day, as I mentioned before, there was a bit of a whack-a-mole approach. Many insider trading cases came into the SEC through FINRA, which is the regulator for broker-dealers, but they also work closely with the exchanges and have a lot of market data available to them. And what would happen is anytime there was a significant capital markets event, say a merger announcement, that type of a thing, FINRA would look at the trade data, look for unusual trading patterns. They would send out information. Many of you in the audience, if you work at a public company, you've seen these requests from FINRA requesting chronologies, who knew what when about a particular transaction. They then work that up to a certain extent, but at the end of the day, FINRA doesn't have jurisdiction to pursue insider trading. They don't have subpoena authority. All they can do is ask their members for information. So they typically refer those over to the SEC. Those wind up on the desk of an SEC staff attorney who then reviews that and will try to look at the trading patterns and see, is there something here? Is there somebody who never bought options before who suddenly was buying options 2 days before a market announcement? And then they were left to try to figure out why that person traded, what information there may be out there about that person, and try to build a case. It was arduous. It required a significant amount of luck. Oftentimes, the luck being, is the person naive enough to speak to the SEC staff attorney on the phone during a cold call? And so it was catch as catch can. Over the last 10 or so years, and certainly by the time I left the agency in 2017, the SEC had developed remarkably sophisticated analytical tools on its own with homegrown SEC staffers who coded analytical tools that could look through data and look for patterns. And so instead of doing this whack-a-mole approach, the SEC's typical approach is to look for patterns. Let's look for something where we can see the same type of trading happening over and over again. So as you look to 10b5-1 plans, you can imagine that what the staff would be doing is looking for occasions where they see executives at a particular company trading timely to various significant events. Then they can go back, try to figure out if there's a 10b5-1 plan. They can try to figure out when those 10b5-1 plans were amended or changed or instituted, and again, try to build a pattern. So you're not trying to go after one particular transaction, but they're looking for opportunities to build a bigger case that helps break down the challenges of circumstantial evidence to say this didn't just happen once, you didn't get lucky once, it's happened every quarter or every year before annual year, the executive is amending their 10b5-1 plan, and lo and behold, there is successful trading afterwards, that type of thing.
So, Sarah, let's say that the staff is relying on these tools that Michael's described. They see some kind of trading or activity that causes an eyebrow to go up, and they're going to reach out to a company to ask some questions. What are the kinds of things they might find at the company that the staff would regard as indicia of wrongdoing? What's going to sort of nudge the staff from "I'm interested" to maybe this feels like a case?
So I'm going to use a legal term of art, which is they're looking for fraudy type conduct. And, what's fraudy can mean a lot of different things in a lot of different contexts. But we have flagged in the overview of the proposed rulemaking what the SEC is looking at as a potential gap or loophole. So in this context, they're looking for places where it looks like somebody is gaming the gaps or the loopholes. And so, things that look like the manipulation of the plan. So rather than having in place an established plan with, once a quarter, I'm going to buy X number of shares and sell, Z number of shares at a particular price. Instead, what I'm doing is repeatedly putting in place a plan close in time. I'm then trading. And then one of the things the SEC is always going to look at is there a profit? So, we've talked about Cheetah Mobile a couple of times. Using Cheetah as your example, the SEC was concerned about a number of things. So one is the SEC alleged that the CEO of the company contributed to or caused the company's misleading statements about a material negative revenue trend. And that in conjunction with having caused that negative material trend, he also put in place a close in time plan and then traded on the plan and saved, according to the allegations of the SEC's complaint, a couple $100,000 in what otherwise would have been trading losses. So here you're basically looking for red flags. The red flag was the timing of the information, knowing that there was an adverse negative revenue trend, in conjunction with the timing that the plan itself was established, so very close in time, both to the revenue trend and to the actual trading activity, and then the amount of losses avoided. And so those are the types of things. It's still in the vein of what Michael described, which is it's all circumstantial evidence, but they're looking for the things that make it look like an executive is not acting in good faith with regard to the existence of the 10b5-1 plan, and that they are benefiting by virtue of that lack of good faith.
All right, Rob, we're going to come back down to you. We've heard sort of about how the SEC investigates these matters, what they're looking for, what they regard as indicia of misconduct. I guess I'm wondering, what is DOJ looking for? How do they find it? How do they cooperate with the SEC in investigations like these?
Yeah, so before I kind of get into the answer there, it probably makes sense to talk a little bit about how insider trading is actually prosecuted both civilly and criminally in the states. Kind of the first paradigm is the commission does the case themselves, which probably represents the overwhelming majority of insider trading cases that are charged. The second paradigm is the department itself, independent of the commission, develops a lead either through a wiretap or through a cooperating witness and will pursue a case on its own. That is fairly rare. And the third paradigm is where the SEC and DOJ are running parallel, not joint investigations into potential illegal behavior in terms of insider trading. And so the question I think becomes, well, in that third paradigm, how does the department and how does the commission work together? How does the department get that case, and kind of what are the rules of the road? And so what I can tell you just from my past experience has been in almost every instance where the DOJ and the commission is working together, there's been a referral in the first instance from the commission to the department. So an affirmative reach out by senior leadership at the commission or staff attorney at the commission. And it'll typically happen early on in the investigation so that criminal investigative tools that are not available to commission staff can be utilized in a proactive way to get at the fraudy type of evidence and conduct that Sarah alluded to. We're talking about conversations, text messages, the opportunity to leverage information to obtain cooperating witnesses can be achieved by criminal investigative tools in a way that the commission unfortunately just can't do. So long way of saying referral by the SEC to the department is very, very typical when there's a parallel investigation. It'll happen early in the case. And in those instances, the department will, for a period, though they're certainly not the experts in the law, they are experts in gathering that type of evidence. And so for a period, commission will stand down to the department while they pursue investigative avenues that could yield high quality evidence of willful conduct.
Let me just take a step back, Rob, because I guess, the first paradigm you described where these are SEC only cases, and that's probably the majority of the cases. I think that makes sense to a lot of people. The sort of, the regulator with civil jurisdiction steps in. So tell me, why do the criminal authorities even care here? What's the interest?
So two things on that point. So there are many offices that prosecute insider trading. It's many criminal offices in the United States, federal criminal offices. Two of note are the Southern District of New York, which has, I think, about 20 prosecutors in that unit, prosecute insider trading cases, among others. And there are about 30 criminal prosecutors in my former office, the Criminal Division's Fraud Section, that prosecute securities and commodities cases. There just aren't enough of those folks to go around to effectively and adequately police the securities markets. That's what the commission does, and they're fantastic at it. So the question then becomes is what's the federal law enforcement interest in prosecuting insider trading? And it comes down to an age-old principle of general deterrence. There is a view, I think probably shared by everybody at this table, that with a few well-placed, strategically wise prosecutions of certain individuals, there can be a general deterrent effect that is achieved and realized in the markets. And that is to say, just in plain English, a prosecution of certain individuals for certain conduct involving certain amounts of money can scare other similarly situated would-be criminals or defendants into engaging in the same behavior. So long story short, the department always will have an interest in offenses of this type where there are high value targets and there's a lot of money at stake to hopefully engender a general deterrent effect.
I would just jump in and make the point that while obviously understanding how much SDNY or DOJ are resource constrained, and obviously the SEC would say the same, although there's, I think, 1,000 lawyers in the Division of Enforcement, roughly. I always think of insider trading as actually the area where there is the most risk of a criminal referral and a criminal prosecution of the areas that the SEC looks at. So you're not talking about record keeping rules. You're not talking about registration type rules. When I'm counseling companies about or parties about trading misuse of MNPI, to me, the mantra is always, this is the one thing that can actually get you, in an orange jumpsuit with bracelets if you're not careful. Whereas a lot of the other areas that the SEC regulates, sure, there's a theoretical risk of a criminal prosecution, but it's very low. But in reality, and particularly from say, I don't know, whatever 2012 through 2016ish, when it wasn't a pre-PRR was saying there was 81 insider trading convictions. There was certainly a heightened focus that this is a great way to wind up in jail. And I think that's something that should be kept in mind as we think about 10b5-1 plans. Now you're moving from rogue traders at expert networks and hedge funds to senior executives at public issuers. And as those plans are being entered into and trading decisions are being made, I think it's just important for people out there to be thinking that this is something that can put you literally at your liberty at jeopardy.
Now, look, it's a great point because at the end of the day, I think the conduct that underpins insider trading at this point in American society is malum in se. Everybody knows it's wrong, and it typically involves a sexy set of facts that everyday jurors can understand. Trading based on secret information that you've stolen for your own personal benefit is a trial-worthy case, and it's one that's, Michael, as you alluded to, if the facts are right, any red-blooded prosecutor would love to take. So, unlike other potentially technical rule violations that may be pursued by the commission or the department, an insider trading case has just a core set of sexy facts that make it very, very appealing for criminal prosecution.
So in those cases, and I'll throw this question to Michael and to Rob. I mean, what are the charges that a defendant might be looking at in the civil context? Or Rob, if it's different, tell us what that might be in a criminal matter.
Well, in the civil context, I mean, it's essentially one charge. It's Section 10B of the Exchange Act of 1934 and Rule 10b-5 thereunder, as we say. That is a full fraud charge. It's the SEC's most serious charge. It's also a challenging charge to bring a case against. It requires proof of scienter or intent. And in a lot of these cases, it relies mostly on circumstantial evidence. But the commission does have a good track record of building cases based on circumstantial evidence, although it's also an area, and maybe Sarah would agree with this, where the SEC loses most often. The SEC has a track record that it likes to tout. It oftentimes is because it only brings to trial cases that it knows it can win. But if you were to look over a segment of history, they're going to lose more insider trading cases than they're going to lose other kinds of insider cases that go to trial. They are challenging to bring, usually because of the quality of the evidence.
So there are four criminal statutes that are used by prosecutors to charge insider trading. The first is, as Michael said, 10b-5, which has a criminal component of engaged in willfully. So 10b-5, number one. There's another statute called 1348, which frankly runs coextensive with 10b-5. There have been a couple court rulings around the United States that have broadened the scope of 1348 over that of 10b-5, but largely the statutes mirror one another. The third and most frequently employed is the federal wire fraud statute, mail-in wire fraud statutes, which sweep broadly. And there is open debate about whether, in the context of an insider trading prosecution that sounds under the wire fraud statute, whether certain of the elements that are required under 10b-5 are still required for a wire fraud prosecution, such as the personal benefit requirement. And so in any event, 1343, that's the wire fraud statute, will almost always be charged in conjunction with 10b-5 or 1348. And lastly, and used less frequently because the context is just different, is the theft of government property statute, which prohibits any person from misappropriating government information. And recently, there have been charges in the Southern District where the allegation has been that a government employee misappropriated information and then used it to trade for their own personal benefit. Instead of going through the rigmarole and the complexities of 10b-5 and 1348 in the wire fraud statute, the government alleged and the defendants were convicted of simply misappropriating government information. And so if the information at issue comes from the United States government, the conduct can be charged through this theft of government property statute.
All right, so I think at this point we understand the rule and how serious the charges can be, what the risks are. But I want to sort of bring us back to this sweep that's going on. Sarah, we know that there are information requests or subpoenas floating out there to companies, and so I guess I would ask you, what should companies be doing now, even if they haven't had the misfortune of having one of those subpoenas land on their desk?
Actually, this ties really nicely into Rob's point on the general deterrence effect of having a couple of really powerful actions a year and what message that sends to the market, because that's basically precisely what's happening with the proposed rulemaking, the sweep, and the Cheetah Mobile case, is that companies and senior execs are looking at their own conduct and saying, are there things I should be doing now in light of this? So on a personal level, it gives me a little bit of pause because it effectively is saying that regulation by enforcement is an effective tool. You bring one enforcement action before the rule is even passed against Cheetah Mobile, and then companies and executives say, maybe I need to be doing all the things that Cheetah Mobile wasn't doing that gave rise to an action. But given that, don't shoot yourself in the foot. That they're out there, that they're investigating this type of conduct, what they're interested in, which are these purported gaps or loopholes. So things that senior executives should be doing is making sure that they are absolutely squeaky clean and could certify, if required to do so, that at the point in time that they entered into their 10B or 10b5-1 plan, they were not in possession of material non-public information. On the issuer side, take a look at your insider trading policies and what you are telling employees, directors, and officers they can and can't do, both with regard to trading pursuant to a 10b5-1 plan, but also, all of their trading activity. So, for example, a number of companies are protectively putting in place a cooling off period and, saying, although this is not yet required, we are saying to our directors, officers, and employees that you cannot trade within 120 days of having established your 10b5-1 plan. Take a look as well at your internal controls and how you are tracking employee trading activity and what information you were requiring from your employees, senior execs, directors, and officers about their trading activity. And you should consider disclosure of your own prospective plans, policies, and procedures, and putting out there to the market and to the SEC what are the internal controls that we have in place that proactively are taking into consideration the pending rulemaking.
All right, Michael, I'm going to ask you to put on, I guess, either your enforcement staff hat or your in-house compliance hat, however you want to look at it. But let's assume that you've gone in and you're doing this kind of internal review. You're looking at the factors of the policies that Sarah has flagged. What are things that a company might find that would cause you to have concern about either the way a policy is designed or the way it's being implemented and maybe needs to be shaken up a little bit?
Yeah, I mean, I think there's two things. First of all, as you flag, Kurt, policies and procedures without sort of review and enforcement are no policies at all, right? It doesn't do you good just to roll out the policy. You need to make sure that employees are following it. And then you also have to find, is there a way that I can check and audit and test against that policy? So obviously, one of the things you're going to find potentially is there just simply too much trading? Is there a pattern that I can see as the compliance person, as the GC? Look, boy, isn't it weird that every quarter this one director comes to me and always asks if they can amend their 10b5-1 plan? Why is that? Nobody else is doing that. So is there something you're seeing from one of your executives or directors that's anomalous to what everyone else is doing? There may be a perfectly fine, legitimate, understandable reason, but if you're doing your diligence as a compliance officer or as a GC, and you can get comfortable that there's a good reason behind it, that would later help if any issues arise. I think there's two recent cases that are instructive for the in-house audience, and these were alluded to by Sarah. One is the Endeavor case, which came out last year, which was a case that basically charged a public company with failing to have adequate internal controls around insider trading or around the misuse of MMPI. What that case really was trying to create a public company version of rules that registered entities live by. So broker dealers have Section 15G, registered investment advisors have 204 Cap A. Those both say, in sum and substance, that the registrant has to have policies and procedures designed to avoid the misuse of MMPI. Given where those entities sit in the market, that makes sense. There is no such rule for public companies. And in the Endeavor case, a 3-2 split commission approved an action that said that a company that allowed trading that was not actually insider trading, there was no insider trading case they could could build. In fact, in part because there was a 10b5-1 plan in place. So, well, there weren't adequate controls in place. The executive shouldn't have been allowed to modify their 10b5-1 plan when they did. Therefore, the internal controls were not adequate, and they brought this charge. It was obviously, even within the commission, controversial, but we take the commission as we find it. And so, those that are out there sitting in a GC role should be aware that an aggressive commission is going to look to use the books and records provisions that they're used to dealing with their internal controls, their financial reporting, their disclosure controls, to potentially build insider trading policies and procedures cases. The other case, which is probably worthy of its own panel, is the Panawak case. And that's sometimes referred to as the shadow trading case. Very briefly, you have a company makes an announcement that it's acquiring another company, and the employee at this company doesn't trade in his own company. He doesn't trade in the target company. He trades in a third company's stock because he draws some conclusions about what he thinks will happen to the market generally and that third party based on his knowledge of how this acquisition will affect the relevant market. There's essentially two ways to think about that case. One is what's called shadow trading, and we'll do another panel on that one. But another way to think about it is to look at the policy that was in place at that company. And that company had a very broad securities trading policy, which said that employees may not trade in any securities based on information that they've learned while working at the company. So one challenge there from an in-house compliance perspective is, how do you enforce that? Are you going to put in place the types of controls that you would find at a broker-dealer or an investment advisor, where you get all employees' brokerage statements so you can check, are they engaged in any kind of trading? It's one thing to say don't trade in your own company's stock. If you say don't trade in any company's stock, how are you as the company going to actually monitor that?
And that's a gift to the Division of Enforcement from an enforcement perspective, because one of the hardest things to prove, of course, is scienter and intent. And trading in violation of a insider trading policy at a company is de facto evidence of scienter from the perspective of the commission. So the broader your policy, this is the flip side of look at your policies and procedures, make sure they're robust. It can also become a tool that the Division of Enforcement can use on the other side.
So, Rob, assuming you've got a client or you're in-house at a company that's identified some of these things that Sarah and Michael are talking about, at what point do you think it would be beneficial, or would you advise a client to think about doing a self-report either to the SEC or the DOJ?
It's actually a pretty fascinating question in the insider trading context, because for those of you who aren't legal nerds like us, there are kind of two theories of insider trading. The first is the classical theory, whereby an insider, an employee of the company, misappropriates, steals the company's information for his or her own benefit. The second theory is the misappropriation theory, where somebody steals somebody else's information in violation of their duty, trades. Lots and lots of cases are prosecuted under the classical theory, where the company is the victim. So you have its own executives, its own employees, its own agents misappropriating its own information. And in that instance, and we talked about this at the department, I'm not aware of any corporate criminal prosecution against a company where the employee, executive, or officer misappropriated that company's information, because the law in the United States is a corporation can only be criminally liable if an employee or agent committed a crime, so insider trading would qualify, but the crime was committed with the intent to benefit the company. And it really is tough to make a credible argument that in the classical theory context, which many cases arise from, that the employee is acting to benefit the company when the employee is stealing the company's information for his or her own benefit. So in that paradigm, a self-report makes a lot of sense if the company has an appetite to have the individual prosecuted. And there is a very, very little relative risk for the company in doing so. Now, contrast that with the misappropriation theory, and we look at the SAC Capital case, where I won't say it's a business model, but part of its business was based on tips of insider information. And in that case, they weren't misappropriating information. They, the executives and officers of the company, the fund, were not misappropriating their own information, but instead getting information in breach of fiduciary duties of others to trade and make money. And so in that instance, the corporation, the fund could properly be prosecuted because, of course, the employees and executives were acting to benefit the company. So in that situation, if that is the case, or a fund or a corporation is received a monetizable benefit from one of its employees insider trading in some form or fashion. Perhaps that's part of their trading portfolio to get inside information and for the proprietary book of the company, trade and make money. If the corporation recognizes that and realizes that it has a pretty easy but complex decision to make. The decision is report or not report. Binary, it's pretty easy. In terms of options, but the analysis is very, very, very difficult because there's a sliding scale of considerations. How likely is it the government will find out? Because self-reporting situations often involve lots of credit given to companies that self-report. So by not self-reporting, if the government finds out, the penalty will almost assuredly be worse. So that's kind of calculation number one. What's the risk of the government finding out? Calculation number two is going to be, well, how much money are we talking about? How much gain was there? Because the government, if there's little gain, the government's probably not going to be interested, and there probably won't be a lot to lose by self-reporting and getting that, virtual certainty that there will be no prosecution based on the low monetary amount of the conducted issue. So those are the two principal considerations that would come to my mind as if I was advising a company, and kind of paradigm number two, the misappropriation situation.
So Michael and Sarah, I want to kick the same question to you, and either of you can take it or both of you, but do you think about this differently in the SEC context, in a world where there's an Endeavor action out there? What sort of tips the scales for you in terms of a self-report?
Yeah, I mean, first thing I'd say on the SEC side is the small dollar value of trading in the event of a self-report is not going to prevent the SEC from bringing in enforcement actions. So if it might significantly decrease your penalty, but basically if you're self-reporting an insider trading violation, SEC is going to want a charge in that case. So it's a little different than the criminal context that Rob was just talking about. The other thing is, I also would put in Rob's first bucket, if my self-report is effectively to throw my senior executive under the bus, that's a different type of self-report. That's not talking about your own misconduct and what cooperation credit you might get that will reduce your ultimate penalties because of having self-reported. If in fact you're self-reporting your own conduct, what the objective is there is to get cooperation credit. I think there is a trend both on the DOJ and the SEC side, and Michael can speak to this as well, of less cooperation credit for more cooperation, for what it's worth. And that definitely has to inform whether or not on this kind of weighing of pros and cons of self-reporting, whether you want to go in. And one thing we had talked about is, if I know there's a sweep, as we do now, I look at the sweep, I look at what's being self-reported or being reported out into the press about what the sweep is looking at. I dust off my own internal controls. I take a look at my company and I say, if there's this sweep going on, it's pretty likely that I'm going to get a letter in the near future or a subpoena request. And it's also pretty likely that the SEC is going to say that my conduct violates, in the same way as other participants in the sweep. That's the one scenario where I could say, in that window of time, once the SEC comes to you, it's too late to cooperate. So if you are aware that there is something going on, and for example, in the context of the text messages that's currently front and center for broker dealers and investment advisors, if you are aware that you have the same exact problems that a bunch of people in a sweep are being prosecuted for, and you're pretty sure that it's not flying under the radar, that it's just a matter of time before the SEC shows up on your doorstep, that's a situation where I might consider going in proactively so that you have the ability to get cooperation credit where you otherwise wouldn't. Because if they come to you first, it's off the table.
Yeah, I agree with that. And I would add that the SEC is often criticized, and I think kind of fairly so, for not doing a good job of making it clear what you get by cooperating. That's sort of an age-old criticism, and I think there's a reason for that criticism. I think of insider trading actually from an individual perspective as one area where there actually is sort of two main benefits that you can easily articulate and that most of the time happen. The first is if you think that you engaged in potential insider trading and you self-report to the SEC, you have a pretty good chance of keeping what your issue being an SEC issue, a Michael Cera problem, as opposed to it becoming a DOJ Rob problem. And again, the way I think about insider trading, that's of paramount importance. You go into the SEC, self-report, they are going to be less likely to refer it over to DOJ. I mean, unless your self-report is, I've been engaged in a giant insider trading ring for the last 7 years and billions of dollars have been made. That's a different story, but sort of a one-off, I misused my 10b5-1 plan or something like that. So that's reason number one. And reason number two is financial penalties. Traditionally, insider trading cases from the SEC's perspective were charged financially as what they thought of as 1 and 1. The one-time disgorgement, what is your losses avoided or your benefits gained through the trading, and a penalty that equaled that amount. There's a Supreme Court case that changed the way they do that, but the effect is the same, which is you pay twice. You pay 2 times what you earned on your trading. So if you made $100, you're going to pay $200. When you cooperate, and if you cooperate early enough, the SEC traditionally will do a halftime penalty. So there is a calculable, cognizable, recognizable benefit to cooperating and self-reporting. However, what Sarah said is critically important, which is you have to go in early. And there's actually evidence anecdotally, and we have direct experience with this, where not only do you need to go in before the SEC comes knocking, but referring back to those FINRA referrals that we talked about, it can be, the SEC can think it's too late if you say work at a public company and one of those FINRA chronology requests come across your desk. If then you self-report, the SEC can say, no, that's too late because a regulator had already reached out. So the challenge is, I think, self-reporting, particularly in this day and age, from an individual perspective, is truly before it's on anyone's radar. It's you make the trade and then you kind of wake up the next morning with a queasy feeling in your stomach and you go, maybe we shouldn't have done that. That's the time to start having that conversation with your counsel.
If I could just jump in real quick, Sarah said something that I think is struck a chord with me. Not that you didn't, Michael, but Sarah in particular did. Let me just give 2 seconds of background. The department does have a kind of carrot and stick policy approach to corporate criminal enforcement. If you fully cooperate, fully remediate, and critically self-disclose, presumptively there will not be a criminal charge. That is in stone criminal division policy. The idea is to incentivize self-reports of individuals, to prosecute individuals, the best and highest use of the department's time and effort, it believes. So there is that carrot stick approach. So if you're in the paradigm number 2, you're an entity, one of your employees has obtained inside information to make money for the company. You might say, hey, look, relatively low dollar amount. We're going to do everything right. We're going to run it into the DOJ and presumptively we won't be prosecuted. But what I'm hearing, but those facts 100% of the time will be communicated to our friends, the department's friends and colleagues at the commission. And if it is true that the commission doesn't have that same philosophy and worldview, that will likely necessarily mean that even if there is coverage, that is to say no charge by the department, there likely will be some corporate consequence with the commission. So something to consider in the decisional calculus.
All right, I have an audience question I want to throw out before we run out of time here, and it has to do, Sarah, with the proposed rule amendments. You mentioned that there could be a possible 120-day cooling off period. That's sort of a window after a trade is created or a plan is created or modified when the executive cannot trade. The question is, now that we've seen Cheetah, should views be changing on that? Should we just expect that 120 days is going to be the rule, or how should companies be thinking about this?
I think Cheetah strongly suggests that 120 days is going to be the rule. And obviously it's got to go through a commission vote. Composition of the commission could change, things could change. But what Cheetah did in its remedies is it pulled in as part of its remedies both the cooling off period. So the CEO agreed on a go forward basis that he will cool off for 120 days before trading on any 10b5-1 plan. And also created effectively a certification and good faith requirement, which is also contemplated by the prospective rulemaking, So again, that particular CEO agreed as part of his relief with the commission that on a go forward basis, he will certify when entering into a 10b5-1 plan that it is on in during a period of time that he is not in possession of MFPI. There also is this very unique provision where essentially it requires reporting by the respondent CEO to Joe Sansone, who is the head of the market abuse unit at the Division of Enforcement, of his trading activity. And so it basically puts in place through the relief that's set out exactly what's contemplated under the rule. And therefore, I think it's a pretty good sign that at least the commissioners who voted in favor of that enforcement action view the rulemaking as the appropriate lines to be drawing in order to fill these gaps.
Michael, you agree? All right. Well, I think we're just about bumping into our time limit here. We don't have time for another question, certainly, and I promise to get you out of here for the second half. Thank you, everyone who tuned in today for the discussion. If we didn't get to your question and you would like to discuss it with us, please feel free to reach out to any one of us directly. We'd be more than happy to chat with you. And again, thank you for joining us for this Quinn Emanuel panel discussion. Hope you all have a good day.